Welcome to this lecture on cybercrime and digital evidence. The session is divided up into 4 sections. The first 3 consider the core concepts, processes, relevant cases and law for cybercrime, digital evidence and digital forensics. The remaining section provides a number of case studies which will be discussed in small groups during the tutorial sessions. This is the first section on cybercrime. You may be forgiven for thinking that cybercrime is something new, or at least that it's only been an issue for the last few decades. However, while it feels like we're still breaking new ground on developing specific legislation for cybercrimes, cybercrime is older than most of us. This gentleman is John Draper, known by the pseudonym Captain Crunch. He was an early hacker in the late 1960s and very early 1970s. Draper worked with a small group of blind phone hackers, known as phone phreaks, to produce an electronic device called a blue box. The blue box generated the tones used by AT&T's phone network system to control access to toll or long-distance phone lines in the United States. He became notorious in 1972 when he was arrested and prosecuted for toll fraud, effectively stealing toll calls from the telephone utility companies. He received a sentence of 5 years probation, and his newfound notoriety resulted in his being contacted by Apple co-founder Steve Wozniak, who, along with Steve Jobs, compared notes with Draper on methods for constructing these now famous blue boxes. Wozniak and Jobs, you see, had set up a small business manufacturing and selling blue boxes even before they designed their first Apple computer. Draper went on later to consult for the fledgling Apple computers, designing Apple's first modem device that connected the Apple II to the phone network. Next we have Kevin Mitnick, who is arguably the most famous computer hacker. Mitnick committed his first unauthorized intrusion into a computer system in 1979, when, at the age of 16, he used a modem and phone number to gain access to Digital Electronic Corporation's ARC system. He accessed and copied DEC's computer software, a crime he was eventually prosecuted and convicted of 9 years later in 1988. He was sentenced to 12 months imprisonment, followed by a 3-year supervised release. Near the end of his supervised release period, though, he's said to have hacked into the voicemail systems of Pacific Bell, a telephone utility. A warrant for breach of probation was issued for his arrest in 1992, and he fled, becoming possibly the first ever cybercriminal fugitive from justice. The 1983 movie War Games is claimed by some to have been loosely based on Mitnick's 1982 hack of the North American Defense Command, or NORAD network. In 1985, there was no law against hacking in the United Kingdom. While it was clear that accessing a computer without permission was wrong, it was not easy to work out which piece of legislation actually applied in a given case. The case that's most often cited as having triggered development of our first Computer Misuse Act is R.V. Gold and Shafreen in 1988. 2 journalists, Gold and Shafreen, had observed and recorded the login details of a generic BT engineer's Prestel View Data account at a public computer fair. Prestel was the database that contained all the telephone service subscriber details for the BT network. In pursuit of a potential story for their employer, they accessed the Prestel database and viewed details of accounts belonging to other people, most famously including Prince Philip. But BT discovered the authorised use of their subscribers database, but because no law at the time covered unauthorised access to a computer system, the pair were charged with fraud pertaining to manufacturing a false instrument under the Forgery and Counterfeiting Act 1981. The prosecution's argument was that by entering their unauthorised commands into the Prestel system, they changed its internal state and somehow created something that infringed on the intellectual property of BT. They were found guilty and fined £750 and £600 respectively. The case, however, highlighted several important facts. First, that BT had not taken computer security seriously, because the username for accessing the Prestel system was simply a list of 8 twos, or 22222222, and the password 1234. And second, it was also clear that the law being applied did not actually suit the facts of the case. It was this last point, that the law didn't suit the case, that the pair argued on appeal. And in acquitting them, Lord Justice Brandon said, "We have accordingly come to the conclusion that the language of the Act was not intended to apply to the situation which was shown to exist in this case. The submissions at the close of the prosecution case should have succeeded. It is a conclusion that we reach without regret. The Procrustean attempt to force these facts into the language of an Act not designed to fit them produced grave difficulties for both the judge and jury, which we will not wish to see repeated. The appellant's conduct amounted in essence, as already stated, to dishonestly gaining access to the relevant Prestel databank by a trick. That is not a criminal offence. If it is thought desirable to make it so, that is a matter for the legislature rather than the courts." Cybercrimes are divided into two types. First, the cyber-dependent crimes, which are those that can only be committed through the use of information and communications technology. That is, through using computers and smartphones and computer networks and the internet. And secondly, the cyber-enabled crimes, which are traditional crimes that can be increased in scale or reach, or more easily committed, through the use of computing devices and the internet. Cyber-dependent crimes fall into two types. Intrusion crimes, such as hacking in order to steal, damage, distort or destroy data, and interference crimes that disrupt computer or network functionality, such as with the use of malware developed or deployed for financial gain, or denial of service attacks. Intrusion occurs when the hacker identifies a vulnerability and gains access to the target organization's computer systems. Intrusion could be performed by what are called white or black hat hackers. White hat hackers are usually those without malfeasant intent. People who will identify a weakness and then advise the system owner what they found and sometimes how it can be fixed. However, in recent times, even some white hat hackers have sought bounties from the organisations before they will reveal the weakness. Bounty hunting on the web has become a business model for some. On the other hand, black hat hackers generally do intend harm of one sort or another. They may be identifying a vulnerability that allows access to the organisation's systems in order to enable some future unlawful act. Or alternatively, they may go on and intend to sell the details of the vulnerability to others, who themselves will perform the cyber-dependent or cyber-enabled crimes. Interference is a little bit different to intrusion. Interference may not necessarily always require direct access to the target organisation's system. This is the case for denial of service attacks, which often use third-party organisations and individual systems and focus them onto the single target's computer system. Many denial of service attacks simply distribute a virus or code embedded within another banal application, the so-called Trojan horse, and therefore the hacker need not actually hack the third-party people's systems because their owners will open the infected email or install the Trojan horse infected application. Another type of interference is parasitic computing, which happens when the attacker uses a vulnerability, possibly discovered through intrusion hacking, to access and run their own code on the target organisation's server systems. Parasitic computing might enable other cyber-enabled crimes like fraud, or it might simply be used to install software on powerful computer servers in the target organisation's data centre and have them perform tasks for the attacker, such as Bitcoin mining. This crime has developed its own name, cryptojacking. There have been numerous high-profile employee-based cryptojacking incidents in recent years. These include at the New York State Department of Education, where one of their IT engineers circumvented security software that was intended to prevent this kind of hacking, and he installed Bitcoin mining code and enabled remote access to monitor his Bitcoin mining from home. and at the United States Federal Reserve Bank, where another employee installed Bitcoin mining software on one of their internal Federal Reserve Board servers. In both of these US cases, the employee not only lost their job and any benefits that that job provided, such as health insurance, but they were also given probation of between 1 and 3 years and fined many thousands of dollars. Some cryptojacking perpetrators have recently gone to jail in the US for as much as 7 years. Consider that when an Australian broadcasting employee was found to have cryptojacked several of their web servers, in order to prevent national embarrassment, the broadcaster didn't actually sack him. Rather, they internally disciplined him and restricted his access to ABC computer systems. When the incident became public, however, many in the public were shocked that he hadn't simply been terminated. In recent years, the scope of traditional crimes that have or can be cyber-enabled has been limited only by the criminal's imagination. The crimes listed on the right-hand side of this slide are but a few examples, and leave out some of the more detestable ones that you might hear about, like cyber pimping of children, the use of online systems to arrange marriages, gender mutilation surgeries, and other things. There is ongoing discussion about the fact that while some computer crimes are better dealt with as cases of fraud, fraud remains an unclear term in English law, with there being laws against conspiracy to defraud and at least 8 different types of deception. And the last one leaves aside the question of whether a computer, which is an inanimate object, can even be deceived. There has also been discussion that breaching digital rights management might be liable under the Computer Misuse Act, even though it's effectively a civil copyright crime. Copyright, breach of contract, privacy, libel, and other laws that are mostly dealt with in our law as civil issues, yet any one of them could find its way into being prosecuted under the current Computer Misuse Act. Meanwhile, new and different technology crimes are being discovered every day. The key thing to remember is that, dependent on your jurisdiction, any of these crimes may now or in future be represented in modern cyber-aware legislation, but many tend to be prosecuted under their traditional criminal legislation counterpart. You, as the lawyer, must ensure that you and the experts you engage are capable of assessing not only the digital evidence itself, but the process by which it was identified, collected, stored, analysed, shared in discovery, and produced in court. The primary act in the United Kingdom that deals with cybercrimes is the Computer Misuse Act 1990. While the original legislation only created 3 offences, and more recent changes have been introduced through other legislation like the Police and Justice Act 2006, the current Computer Misuse Act creates 5 core offences. A person can be prosecuted and may be found guilty of a crime if either they or the computer in question are located in the United Kingdom at the time of the offence. The first offence created by the Computer Misuse Act is that of unauthorised access to computer material under Section 1. This is an offence where the person is found guilty if they cause the computer to perform a function with the intent of securing access to any program or data held in a computer, or if they enable such access to be secured. The actus reus is substantiated by causing the computer to perform the function in order to secure access to it. Now, it has been argued that the simple act of opening a file on the desktop of a computer could be sufficient to substantiate this offence, even if it's not apparent what, if any, data the file may contain. For example, in Ellis v DPP, which is a 2001 case, the appellate was a student of a university and had been given authorised access to non-restricted systems. He appealed 3 convictions for using other restricted systems that he knew he was not authorised to use, but that had been left logged in and accessible by their authorised users. He admitted using the restricted computer for the seemingly innocuous task of browsing the internet, something he could have done from any of the terminals that he was authorised to access. And he claimed that his browsing consisted merely of hitting the back button to see what websites were accessed by the authorised restricted user who'd previously been at that terminal. His appeal was accordingly dismissed. The mens rea of this offence requires the intention to secure what the person knows to be unauthorised access and cannot be made out by mere recklessness. So, for example, if someone was merely slapping at the keyboard and suddenly find themselves that they've accidentally hit the right combination of keys to unlock the terminal, it might not in and of itself provide the requisite intent. That is, providing, for example, that they do nothing more to the computer and that they alert someone who's authorised that the computer is unlocked and needs to be secured. If they accidentally unlocked the terminal and then started to look at files in the terminal, that would likely substantiate the offence. This offence carries up to 12 months imprisonment on a summary offence and 2 years on an indictable offence. The second offence created by the Computer Misuse Act is that of intent to commit or facilitate further offences under Section 2. Now, Section 2 is essentially an extension of the offence that we covered in Section 1. However, it's where the prosecution can show that the conduct that would have been a breach of Section 1 was done in order to facilitate additional offences. The actus reus, therefore, of this offence is the same as that for the offence under Section 1. However, the mens rea requires not only the intent to access the computer and the knowledge that that access is unauthorised, but the additional requirement that the person intends either to commit a further offence or that they're intending to facilitate the commission of other offences, whether alone or with other people. The further offence need not actually occur or be substantiated in the prosecution, or it need not even be possible. Nor is there a requirement that this offence be proximal in time to the unauthorised access in order to substantiate an offence under Section 2. Nor is it a requirement that the further offence even have been committed or intended to be committed by the person who secures the unauthorised access. Now, while this offence carries an unlimited fine, it can also carry up to 12 months imprisonment on a summary offence and 5 years on an indictment. The third offence under the Computer Misuse Act is that of impairing operation of a computer. Now, an unauthorised modification to a computer could include such things as spreading a virus and infecting that computer with it. It might include a ransomware attack where you've encrypted the files and you're demanding payment for revealing the unlock key. Or it could be that you've sent a program to the computer that redirects all of its browser home pages. Now, while this offence is building on Section 1, which is unauthorised access, it's building on it to look at unauthorised modification, so it's looking at the result of what you've done with that access. The actus reus is fairly broad. It encompasses any unauthorised act in relation to a computer, including both doing the unauthorised act and causing the unauthorised act to be done. However, it's not necessary for the prosecution to prove that any impairment actually resulted from your act, and if any impairment does actually take place, it need not be anything more than temporary. So if you think about that broadly, if I was to send you an email and in that email I had a link to a file, and my intention is that hopefully you will click on that file and that file will infect your computer with a program that allows me to access the computer, or it allows me to log your keystrokes and see what you're doing on your computer. Sending the email could in and of itself form the actus reus. Whether or not you click on the link doesn't matter. Whether or not if you do click on the link, the program actually does install to the computer doesn't matter. Whether or not I get any data from the keylogger doesn't matter. Simply sending it could form the actus reus. Now, the mens rea for Section 3 offence has two components. Firstly, that the act is obviously intentional and the person doing the act knows that it's unauthorised. Second, either the intention to cause the impairment or that you're completely reckless as to the possibility that impairment could result. Now, whilst carrying an unlimited fine, this offence also carries up to 12 months imprisonment on a summary offence and 10 years on an indictment. The fourth offence created by the Computer Misuse Act is that of causing serious damage under Section 3ZA. Here, we're not just building on the Section 1 offence of unauthorised access, but we're also building beyond the Section 3 offence of impairing operation, in order to consider the resulting outcome or the impact, beyond the immediate computer system and out in the wider community. The actus reus of this offence involves unauthorised acts in relation to a computer where those acts cause or create a significant risk of causing serious damage of a material kind. The mens rea is that at the time of the acts, the person knew them to be unauthorised and intended them to cause serious damage of a material kind, or they were reckless as to whether or not such damage could be caused. So let's take a theoretical example. Utility companies often use a system called SCADA switches. These are little electrical devices that you can put on a network, or you can give them a modem and dial into them. And they turn an electrical signal, so an instruction to do something, into a mechanical signal. Now that might be that they turn on a transformer at the power company, or it could be that they open or close pipes for the water board. So consider somebody hacking these computerized SCADA switches used by the water board to remotely control peak flow at a large dam spillway. Now they could send digital instructions to those switches to assume the wide open position and allow full flow across the spillway gates. Now that would conceivably not just harm the residents downstream of the dam in a very immediate and tangible way, their town could flood, but it could also conceivably create a situation where residents in surrounding towns have to suffer water restrictions, or where the council would have to truck in daily supplies of potable clean water at some point in the next few months. Both outcomes would give rise to a prosecution under Section 3ZA. Now, you'll notice in the damage of material kind list I've got there, we've got damage to human welfare. Now, the Act very, very specifically lists what they mean by damage to human welfare, and it includes loss of life, it includes causing human illness or injury, disruption of a supply of money, food, water, energy or fuel, disruption of a system of communication, disruption of facilities for transport, and disruption of services relating to health. So if you take the scenario that I just laid out, the flood gets into the town, there's a small hospital in the town with an accident and emergency department that can't be used because it's now under 2 feet of water. Well, that would be sufficient to create an offence. However, it gets even worse. If by not being available, that accident and emergency department cannot be accessed by somebody who has a serious life-threatening illness and they die, well then you've escalated that to loss of human life. The reason that the type of damage is important is because the type of damage sets the penalty, the maximum penalty that an offender could foreseeably have levied against them. An offence for the economy or the environment might get 12 months imprisonment on a summary offence, 14 years on an indictable offence, and either one could carry an unlimited fine. However, it raises to life imprisonment where the act results in serious damage to human welfare or where the act impinges upon national security. The fifth and final offence under the Computer Misuse Act is facilitation of unauthorised access under Section 3A. Section 3A effectively creates 3 sub-offences: production, provision and procurement, that share 2 common elements. One is that it's an offence relating to an article, and that article could be a production of a computer program, so some code. It could be production of backdoor passwords. It could be an instruction sheet for how to access a particular system. So it could be a wide variety of things that allow intrusion into a computer. The other common element is that in each case, this article is used in commission or assistance of commission of an offence under Sections 1 or 3 of the Act. Now, the actus reus of Section 3A1, which is the production offence, involves making, adapting, supplying, or even offering to supply an article for use in the commission or assisting in the commission of an offence. The mens rea is intention, that the article should be used in the commission of that offence. So it's very specific here. Not only are you supplying it or you're producing it, but you have intent that this is the function it will perform, that it will assist in doing this particular act. So an example would be if you produced a piece of software, so if you wrote the code for a piece of software with the intention that it was to be used specifically to access our university network and allow the changing of exam results in the servers that hold the student grades. The actus reus of a Section 3A2 offence, which is the provision offence, involves supplying or offering to supply an article for use in the commission or assistance in commission of an offence. Now, the mens rea requirement is broader, as it requires only the mere belief that the article is likely to be used for such a purpose. So here you've got that you may not necessarily have produced it, but you've got it and you're offering it to somebody. You may not necessarily have tested it and know for sure that it will definitely allow them access to the grades server, but you believe that it will probably do what they want. So an example would be if you offered to supply or supplied this exam result changing program to another student believing that they could use it to change their own grades. So a little bit softer requirement in the mens rea. The actus reus of a section 3A3 procurement offence is simply the obtaining of an article, and the mens rea is the intention to obtain it with a view that the article could be used to commit or assist in the commission of the offence. So an example here would be if you came to me and asked me to create you a grade changing application. Okay, you've asked me for an application that does a particular function with a view that what I give you back will do that function. You're effectively procuring it, whether you're procuring it for your own use or to, for example, sell to somebody else. Now, as I've noted through that, the strength of the mens rea requirement, the term at the end of each line, if you like, for the three offences, that is required to be made out for each offence becomes more broad as we move down through the sub-offences: intending, believing, and finally just with a view. This effectively makes the evidential requirement for the mens rea, for the mental element, less stringent. So for the first offence, it would have to be shown that you supplied or possibly even developed the software. You know, your hands are on the keyboard. Either you've written the code, or you've emailed it to me, or you've copied it onto the memory stick for me. And you're intending, you know that this thing does what you're saying it does on the tin, and you're intending that I'm going to use it to do that act. So it's possible as well, it's been theorized that it's possible that if you wrote the code and analysis of the content of the code shows that it has identification of particular university servers, particular university databases, and that those servers and databases are the servers and databases that support this particular act, then it's possible that the code itself, if proven to be your code, could make out both the act and the mental element of this offence. But when we get all the way down to procurement could be something as simple as you asking me to create you the piece of software, and that request could be sufficient to meet both requirements. This particular section of the Act has been the subject of some pretty regular negative attention academically, in that it potentially makes the academic study or the academic development of or testing or publications about hacking tools a criminal offence. Now, I'm not directly aware of any academic being prosecuted in this way, but there are a number of law journal articles and a number of conference talks available on the internet that discuss how an academic or, for example, a PhD student in the computer science department could potentially be prosecuted for either a provisional procurement offence for something as simple as writing an article about here's how this hacking tool works to jailbreak your iPhone. The offence carries an unlimited fine in all cases, but up to 12 months imprisonment on a summary offence and 2 years on an indictment. The next two slides simply demonstrate the breadth of cyber-enabled crimes that are often prosecuted under the relevant sections of their own legislation. So you'll see here things like offences with relation to obtaining or disclosing or procuring or altering personal data. They could be prosecuted under the Computer Misuse Act, or they could be prosecuted under provisions in the Data Protection Act. We've got the same for theft, intellectual property, improper communications, unlawful interception of communications, child pornography has its own set of legislation, obscene publications, and cyber harassment and cyber stalking. So often what you'll actually see in court is that many of these offences will be prosecuted under their home legislation, and leaving aside the computer misuse element, and all that will happen is that some digital evidence will be produced in court to support that traditional prosecution. One online source claims that more than 80% of UK businesses are affected each year by cybercrime, well, specifically in 2019 and 2020. They also claim that the most common attack was 55% were targeted by ransomware attacks, which are those attacks where all of the information in your computer gets encrypted and you get an alert on the screen that says, pay us so many Bitcoin and we'll send you the key to unlock the encryption. And it's claimed in this report that the average cost per attack was £840,000. Now, think critically about what this article says. It was written by a journalist for an online IT magazine. That magazine, shown here, presents and reviews top 10 lists, which are effectively paid marketing couched as journalistic review. And ultimately, most of what's on this website is intended, the author admits, to paint a particular picture. What her statistics mean is that if each of you was to name 10 businesses on the high street down the road, or 10 tradespeople on the high street, and that could be anyone from large, well-known brand chain stores all the way through to, little ma and pa shops. This report, shown here, suggests that 8 out of that 10 have experienced a significant cyber attack during the 2019-2020 year, and that over half of them experienced a ransomware attack with the average loss of £840,000. If nothing else, this article is a lesson in looking at and critically considering data that you find on the internet, which is just as important when we read the newspaper as it is when we consider, for example, digital evidence in court. The possible mistake such a report makes is the aggregation of sources. Sophos is one company that's used to identify an average cost, but the Sophos report that they link to claims a different number of affected businesses and is reporting mostly larger Fortune 500 companies, certainly not representative of the majority of UK businesses. They use a Kaspersky report, which is also a customer survey that's used to identify how many instances of attacks occurred. And they aggregate some national police databases from the NPIC dashboard to tie all of these and some other random sources together. It's quite a messy article, it's clearly exaggerated and potentially, probably deliberately, misleading. It works very well to sell VPN and antivirus and security consultancy services and is couched to strike fear into computer users everywhere. Another report for the same period comes from a company called Nexor. They're a UK-based IT consultancy that analysed a single source. They analysed police reporting data for hacking of corporate and business systems during the same period. While they and the police both acknowledge that many cybercrimes go unreported, these figures are at least based on analysis of real reports rather than interpretation of self-selected and potentially biased surveys and a picture of what a journalist would have us believe. So you'll see here that in this case they're saying only 3,445 UK businesses were affected in that period, that the most common hacking event with almost the same percentage was that they were hacked through email or social media, and that the total loss of the 53% who were hacked in this way was only 2.9 million. Now that works out, if you divide it, it works out to something like £1,200 or £1,400 per incident, which is much different to £870,000. The second most common hacking attempt, they said, was hacking of servers. So nowhere in there do we even see ransomware attacks. They say the total losses for the whole 3,445 UK businesses came to 6.2 million. That's the losses recorded by the police in their reports. Now that works out to, about £1,800 or £2,000 per instance. And the year-on-year increase of hacking is about 31%. While the previous slide dealt with police reports of hacking of corporate and business systems, this slide here is actually showing you data from the United Kingdom's Office of National Statistics on community-wide reports and prosecutions for computer misuse. This includes both cyber-dependent and cyber-enabled crimes. These statistics, you'll notice there that, there's 1.7 million reported instances of computer misuse in the United Kingdom during this year. That 1.36 of them were unauthorized access to personal information. Now that could include hacking. It could also include just somebody losing a memory stick on the train. But capsulated within that 1.36 million are these offences. So for example, when a grandmother and her solicitor's emails were hacked by fraudsters who told the grandmother to transfer the purchase price of her new flat to a different bank account that was in control of the fraudsters. Or when another grandmother here received 2 calls from a coordinated fraudster who manipulated her to use her online banking website to transfer her life savings into an account that they had set up. And it also includes many hundreds of instances of a combined phishing and fraud scam that targeted people via text messages to both collect personal details for use in other identity frauds, whilst also collecting their credit card details and taking payments from those credit cards for falsely claimed unpaid parcel delivery fees. While the statistics we saw on the previous slide from the ONS suggest that as many as 1.7 million cybercrimes have occurred in the UK during a 12-month period, what they don't tell you is that less than 1,000 of those crimes actually commenced prosecution, and only a few hundred of them got to the end of that prosecution. There are many reasons why cybercrimes are rarely prosecuted. The first one is jurisdiction. While many laws now contain inclusions with regard to prosecuting crimes that have occurred across borders, for example, here our Computer Misuse Act provides that a cybercrime may be prosecuted where there is simply a significant link to the UK. So it could be that the perpetrator or the victim reside in the United Kingdom, or that the computer system resided in the United Kingdom at the time of the attack. And the same is true conversely, where it's a UK citizen who has performed an act that took place in another country. So a UK citizen hacking the bank server of a French bank or a German bank. Our Computer Misuse Act contains a reciprocal arrangement provision that would allow that country to request your extradition or prosecution for that offence. However, while we have these reciprocal legal rules with many of our allied countries, there are also many countries like China and Russia who wouldn't honour our arrest warrant any more than we would honour theirs. So if the perpetrator is in Russia or China or in a number of African countries, it's very unlikely that the victim here in the United Kingdom is going to ever see a prosecution of that person. While much of the UK has one consistent set of laws, leaving aside that Scotland, Wales and Northern Ireland can have the power to create some laws of their own, other jurisdictions like the United States and Australia have an added complication in that they have both state and federal laws that can variously be invoked depending on who the target was, whether or not the act crossed state lines, and the financial value of the loss or the damage that was suffered. The key thing to understand here is that jurisdiction may not always be obvious with cybercrimes. The second reason that cybercrimes are rarely prosecuted is simply underreporting. The vast majority of cybercrimes do go unreported, whether that's because people do not know how or where to report a cybercrime, whether they're embarrassed that they've been taken, or whether it's because they believe, often correctly, that nothing will come of reporting it. It's also noticed that for some businesses and corporations, even a cybercrime with a significant loss, like say £20,000, could cost many more times than that to investigate it, prosecute it, and then try and recover the funds. So it's pretty clear that when someone loses £500 to a cybercriminal who's probably located in a jurisdiction outside our own, resources are probably not going to be assigned to investigating and recovering and prosecuting that person beyond filling out the form and filing it with the police and your insurance company. Because most cybercrimes go unreported, accurate statistics describing the true scope of cybercrime simply don't exist. The third reason is complexity. Anything involving computers and the internet can be extremely technical. Tracking down cybercriminals can be resource intensive, and they often know how to cover their tracks. A 2010 study of police force preparedness for cybercrime found that most UK police acknowledge their lack of expertise to conduct investigations in cyberspace. Another study that was conducted 2 years later found that 80% of individual police officers admitted their limited knowledge and expressed reluctance to be involved in cybercrime investigation. Ambiguity around the definition of cybercrimes means that the few that make it to court are more often prosecuted under a traditional legislation, with the cybercrime elements of the crime and the role of any digital evidence downplayed. The final reason why cybercrimes are rarely prosecuted is the evidence. While most police and lawyers think that they understand cybercrimes, and they think they understand computers, they use them every day, and they even think that they understand digital evidence, well, it's just another form of evidence, isn't it? No. Investigating, identifying, collecting, and even evaluating evidence of a cybercrime is actually quite difficult and time-consuming, especially if you want that evidence to stand up in court. There are a range of important questions that the good lawyer must ask whenever they're presented with digital evidence. Can any of you suggest some?